Hello students, and welcome to week 6. This is your tutorial on the doctrine of precedent. This week we're going to look firstly at your major essay question, and then we'll move on to talking about precedents. So your major essay, so this is task number 2, is due on Tuesday the 4th of October by 5 p.m. It's a 2,000 word essay and it's worth 40%. Now the question, which clearly is a question about access to justice, which was last week's topic, is as follows. Persons who have served time in prison may be disadvantaged in their encounter with justice or the Australian legal system. Describe, critically explore and demonstrate your understanding of the problems they may experience in gaining equal access to justice and the legal system. Also discuss how race and gender may affect access. And use an Australian case study in your example. So I suggest that you have a look at newspaper articles first to try and find examples of ex-prisoners and the types of problems that they face. I have found actually a journal article on the high mortality rate of ex-prisoners, and I'm going to put that up on Blackboard shortly to assist you. The criteria is up on Blackboard and it's also in your course outline. So have a look at this because you are again being evaluated on your knowledge, understanding, academic research skills and academic writing skills. Now this is a research exercise, so there's a slightly higher expectation around research this time. And please use academic writing, don't write in a conversational tone. So moving on to what is the doctrine of precedent? Well, firstly, what is a precedent? In common law legal systems, a precedent or an authority is a legal case establishing a principle or rule that a court or other judicial body adopts when deciding subsequent cases with similar issues or facts. Now I've included an animated clip for you to have a look at on YouTube, so please just put that link in and have a look at this clip either now or at the end of the tutorial. Look, it's a simple way of understanding precedents, so hopefully you'll enjoy it and get a better understanding. And hopefully you've also had a chance to listen to this week's lecture on this topic. So your tutorial questions, which are up on Blackboard, I'm going to go through one at a time. So what is the doctrine of precedent? Well, the doctrine is a rigid adherence to precedent. Described as stare decisis, meaning let the decision stand, it separates the function of courts from representative parliament. The development of a reliable and coherent system of law reporting and changes in the appeal structure of English courts facilitated the adherence to precedents. Now, when is a precedent binding on a court? Well, lower courts are bound by decision of higher courts in the same hierarchy. Higher courts can correct the decisions of lower courts within the same hierarchy. And decisions in other common law countries, for example the United States, are persuasive, not binding, and I'll talk a bit more about that in a moment. So how does this doctrine operate? Let's explain the operation of precedent in relation to the federal and state hierarchies. Now remember that there are two hierarchies in each state, being the federal and the state. And on top of that, we have the High Court sitting at the apex. Appeals to the High Court can occur, but they require special leave. So let's have a look at the federal court structure first. Breaking it down, the full court of the family court and the federal court are bound by decisions of the full court of the High Court on constitution and also interpretation of federal statutes and common law. A single judge of the federal court is bound to follow the decision of the full court of the federal court. A single judge of the family court is bound to follow a decision of the full court of the family court. And federal magistrates' courts are bound by both federal court and family court decisions. In relation to the state hierarchy, state appellate courts are bound by decisions of the full court of the High Court, again on constitutional matters and the common law, as well as on matters of statutory interpretation relevant to the state. State appellate courts are not strictly bound by their own prior decisions, nor are they bound by decisions of other state courts at the same level, although the decisions are generally persuasive. Single judges of supreme state courts are bound by decisions of the appellate court of the same state, although not strictly by the appellate court of another state, again persuasive. Magistrates and intermediate courts, the judges there are bound by decisions at the appellate level of the Supreme Court in their state. A single Supreme Court judge is similarly bound. There is some argument as to whether the decisions of the district court bind the local courts, such as the magistrates' court, as only superior courts actually have the authority to make precedents. So why is the doctrine of precedent important? And is there a relationship between the doctrine of precedent and the rule of law? Well, the doctrine of precedent refers to the way judges make law and decide cases by referring to previous decisions or precedents. And the justifications for this adherence to precedents include the following: that like cases should be treated alike. So in other words, that there is consistency between cases. That there is a need for certainty in the law. So we should gain some confidence that there is certainty in the law when we see the law applied in the same way. And the need for predictability. This also gives us confidence in knowing that how a case of similar fact and issue was dealt with before will be how this case before the court is also dealt with. And adherence to precedent also allows that people should know what the law is in order to be able to obey it. So how does precedent aid in decision making in general? Well, judges cannot base their decisions on prejudice or personal whim or politics. A precedent is simply something that has gone before and is called upon as a model for later policy or practice. Precedent is useful because it is generally quicker and easier to resolve a dispute by reference to a previous decision in a similar matter than by considering a dispute on its individual merits each and every time. The use of precedents discourages arbitrary decision making and brings a measure of certainty and stability to the process. At the same time, precedent allows considerable flexibility because of the great variety of fact situations which give rise to disputes. Now, recalling your knowledge of the constitutional framework from week 3, I want you to have a think about why the High Court tends to overrule itself more readily in constitutional cases than in cases involving the common law or statute. And like every other question that's posed in the tutorial, I ask that you think about it before you listen to my response. Firstly, the Australia Act in 1986 abolished appeals to the Privy Council in England, so it made the High Court of Australia the highest court of the land. And the High Court deals primarily with constitutional matters. The Constitution is subject to the interpretation of the High Court, which is not bound by any other court. Appeals to the High Court can be made, but only on points of law. Decisions are overruled if they are deemed as bad law. So think about the Mabo case. The High Court is reluctant to overrule common law decisions which have already been through the appeal process and are based on precedents in the relevant states. With regard to statute law, which is made by Parliament, another body of lawmaking in Australia, the High Court does not readily overrule statutes. However, in the obiter, in the Mabo number 2 case, for example, we see the Parliament was influenced to change the law in relation to native title. The resulting change in the statute meant that precedents were affected. So this Mabo case in the High Court became a precedent after the Act became law. So that is the Native Title Act. Still, in relation to the operation of the doctrine of precedent, we're going to look at a number of elements. Firstly, ratio decidendi, obiter dicta, and when precedents are binding and persuasive. So let's have a look at the ratio to begin with. What is it? Well, there's two important facts. A ratio is a legal rule or principle that decides a case. And to analyse a case, you have to be able to identify the ratio. So the case itself is the precedent, but the legal rule or the principle that decides that particular case is the ratio. So that's what you have to find in the case. Now, we know that the facts of all cases change. And so the ratio is the reason for deciding, and it is only the ratio that forms the precedent for later decisions. If the facts of a precedent of a higher court in the same hierarchy are similar to the facts of a present case, a court must apply or follow the ratio, so the legal reason behind that ruling. And it's got to do this when there is no reasonable distinction, so it's followed, so there's a term that you'll see. A precedent may be applied when there is some reasonable distinction between the two cases, but it's not regarded as one which should be acted on. And finally, if the facts are different, the case may be distinguished by the lower court and therefore not treated as binding at all. So the court has to look at the precedents that are put up in relation to the case that it is dealing with to decide whether or not it is relevant to the case before the court. So how do courts decide cases? The facts must be authoritatively ascertained, either by the court at first instance or less frequently at the appellate level. This requires the court to make assessment as to which facts are relevant or material. The legal rule or rules relevant to the issues raised by the facts must be identified and explored. The legal rule or rules must be applied to the facts as they're found. This application of the law to the facts produces the reason for the decision. Now, why is it only the ratio which binds a later court? Well, the facts of all cases change. The ratio is the reason for deciding, and it is only the ratio that forms the precedent for later decisions. Other statements about the law are obiter dicta, which means by the way. So the ratio is the binding part of the precedent. And a precedent is used when there is no statute of relevance to the case at hand, and the case at hand has the like facts and similar circumstances to the past case, as we've heard. So the judge then must decide as to whether the precedent is binding or persuasive. Before that happens, there can be obiter. So this is where other statements about the law are included. So in the obiter dicta, which means by the way. So here we see the persuasive part of the precedent. And this does not form part of the ratio of the case. So obiter, all other decisions in a case are merely obiter and not strictly binding, but they may be persuasive. So in other words, they're included here. Comments, opinions, observations made by the judge throughout the judgment are made here. And they're often referred to as a statement or statement said by the way. And the reason that they're important is because in future cases, the judges may look to the obiter to get an understanding of what the judge was considering in the case, even though the ratio may not apply to the case before the court. So the court's still interested in, well, what did the judge have to say, because it seems to be a similar case. But the binding part of the precedent we're going to look at now. So when is a precedent binding on a court? So if you look at this diagram, you see a past case. Case A lists the facts. The current case has similar facts, similar issues. So the judgment of that first case, that previous case, becomes a precedent for this case. But we need to look at the court structure to see how it applies. Well, precedents, as we've heard, apply in a downward direction. So the federal courts or Commonwealth courts listed there, we see that the precedents are applicable, binding in a downward direction. So we've heard federal and family courts on the federal magistrates courts. At a territory and state structure, we hear that they are binding in a downward direction. We also have, of course, the Supreme Court, Court of Appeal. So that's binding on the Supreme Court and so forth down through the structure. And of course, any decisions made by the High Court are binding down through both of those structures. So lower courts are bound by decisions of higher courts. Higher courts can correct the decisions of lower courts in the same hierarchy. Only the ratio from a court of record, which means so where the court that decided the case sits, can create a binding precedent. Binding precedent only binds courts in the same level or lower in the same hierarchy of courts. A court is part of a hierarchy if it's linked by the right of appeal. So if you look back at the court structure, the appeal process goes up through those courts. So following that same line, you can then be assured that the appeals process going up is mirrored then by the precedent binding process going down through that same hierarchy. And the position of the court of record, or where it's been decided, in the court hierarchy will determine whether the ratio is actually binding or persuasive. So, by way of example, a district court, let's say, is bound to follow a decision on a point already made by a Supreme Court, referring to the two conditions that I'm going to give you that need to be satisfied. The previously decided point must have been the ratio of the case in which it was decided. That means the essential point of law which the previous court was required to decide in order to dispose of that case before it. And the previous court must have been a higher court than the present court, or arguably at the same level. So what this is saying is that there's actually a judicial food chain, if you like. So the High Court's not bound by any other court. The District Court is bound by the Supreme Court, but not the Magistrates' Court, and the Magistrates' Court is bound by all courts. So what is persuasive argument then? These are statements of principle not strictly necessary for the decision and are not binding, but nevertheless are still important statements. By way of example, decisions made in other common law countries, so like I said, the United States or England, will be persuasive on our courts but not binding. Statements of principle not necessarily statements of principle not strictly necessary for a decision and not binding as such by a court of record are only persuasive in value. So they're in the obiter. Decisions of courts in other court hierarchies are only persuasive, so they influence the decision. So by that, if you think of the New South Wales court system, then a decision of the Supreme Court in New South Wales will only be persuasive on a decision in the Supreme Court of Queensland. The persuasive value of obiter, or a decision from a court in another hierarchy, will depend on the status of the court in that other hierarchy and also the status of the judge. So if we think of a decision made in the Supreme Court Court of Appeal in New South Wales in relation to a matter that the Supreme Court of Queensland is hearing, then they may very well be persuaded by that decision, given that it is slightly higher in the hierarchy. Okay. So explain how lawmaking by judges differs from lawmaking by Parliament. Well, I think you know by now that judges make laws by deciding cases, and Parliament makes law by passing legislation, and that becomes statute law. Statutes are the major source of law today. Parliament may legislate where the common law has developed in a way that is considered undesirable on policy grounds. Parliament may also legislate by a landmark judicial decision, such as the Native Title Act. And this was enacted, as you know, in response to Mabo No. 2. Judges can only determine specific disputes between parties to proceedings in relation to which the court has power to act. That is, the dispute must fall within a recognised legal classification and the parties must be entitled to invoke the court's jurisdiction. It is Parliament's role to make laws of general application based on policy and political belief. By contrast, the lawmaking role of courts is much more limited. In an adversarial legal system, it is the parties who are responsible for defining the scope of the questions the court has to decide. The judge's authority does not extend to a general inquiry into uncontested issues. In disputes, the court has to determine the preferable version of events and apply the relevant law to the facts as found. Most cases are determined by courts at the lowest level of the hierarchy. It is the appellate level, however, that a dispute is most likely to turn on a question of law. So let's turn now to the case of Donoghue and Stevenson to get an overall picture of both precedent and ratio. So the facts of Donoghue and Stevenson, which appear in your textbook on page 272, are as follows. And I've quoted directly from your text. On 26 August 1928, the appellant, Mrs. May Donoghue, drank a bottle of ginger beer allegedly manufactured by the respondent, Mr. David Stevenson, which a friend actually had bought from the retailer, being a coffee shop they're in, and given it to her. The bottle allegedly contained the decomposed remains of a snail, which were not and could not be detected until the greater part of the contents of the bottle had been consumed. As a result, Donoghue alleged that she suffered from shock and severe gastroenteritis. Donoghue commenced legal proceedings against the manufacturer. Now, the plaintiff, so Donoghue, argued that the ginger beer bottle was manufactured by the defendant to be sold to the public, and that it was the duty of the defendant to ensure that no snails got into the bottle and to inspect that there was nothing in the bottles when the ginger beer was poured in and the bottle was sealed, so during that manufacturing process. And that the defendant then actually failed in both of these duties. The defendant, however, argued that the argument raised by the plaintiff is irrelevant and insufficient to support the conclusion reached in her summons, due to the fact that it doesn't fit into any recognised categories for liability. So at that time, because this is a very old case, what they were saying was that there was no contract between the parties. So, question of law versus question of fact. The court must know the facts as well as the legal issue, but they are the deciders of law. So the legal question is a manufacturer of a product legally liable for any injury caused to the ultimate consumer of the manufactured product? Interestingly, in this case, there was doubt around whether the defendant, Stevenson, actually manufactured the ginger beer consumed by Donoghue. So had this been a trial with a jury, now remember this is an appeal, and this question of fact raised, the outcome may have been quite different, and we may have ended up with this case not ever becoming the precedent for a duty of care. Nevertheless, this issue of fact was not raised, and so the Court of Appeal looked at the question of the legal issues involved. So the decisions of 3 judges are actually discussed in your text, and these are assenting judges. So Lord Atkin, Lord Thankerton and Lord Macmillan. Lord Buckmaster dissented, and we're not going to actually discuss his reasoning. What's important to know here is that judges may reach the same decision or ratio, but they may do so based on different approaches to legal reasoning. So we see here Lord Atkin having discussed the relations that give rise to a duty of care. So he developed the neighbour principle. That is, that you must not injure your neighbour. So this was the basis of his ratio, this principle. So he explored who then is your neighbour. and he determined persons who are closely and directly affected by a person's act, that person should reasonably have contemplated this act as affecting that other person when considering their act or omission. So in other words, when they're doing an act like manufacturing ginger beer, that they need to contemplate, have in mind that their actions may in fact affect a third party. So that third party becomes their neighbour, even though they may not know who that third party is going to be. So the ratio, according to Lord Atkin, that a manufacturer of products who sells them in a form that he intends to be the form that the ultimate consumer receives them in, so the consumer doesn't have any possibility of examining them, and who knows that with the absence of reasonable care in producing those products may result in injury to the consumer's life or property, owes a duty to the consumer to take reasonable care. Now, Lord Thankerton reached the same ratio but did not use Atkin's neighbour principle. He focused on the fact that the intermediate handler, so let's say the coffee shop and the coffee shop owner, has no way of examining or interfering with the product, so the original manufacturer of the product has a duty to exercise diligence in the product's manufacture. Lord Macmillan similarly reached the ratio but focused on the right of action to a party injured by negligence, even where a contract does not exist between them. And he also talked about negligence being never closed. That is, in future, there must be opportunity to look at different circumstances in each case to determine whether a relationship between parties can be established. So if a person engages in manufacturing anything for his financial gain, then he owes a duty of care to the consumer. Now, your tutorial question asks you to explain how Donoghue and Stevenson demonstrates the generalizability of material facts at different levels and the relevance of this process to the formulation of the ratio. The ratio is a generalization of the material facts, and these facts can be generalized at different levels. The dead snail, for example, could be generalized at increasing levels of abstraction to become, for example, any dead mollusk, or any foreign body, or any defect, and so on. The higher the level of generality of each of the facts, the wider the scope of the resulting ratio. Different judges may reach the same result in a case, but for different reasons, as we've heard. Alternatively, they may rely on the same legal rule or principle, but apply it differently to the facts. This makes identification of the ratio often difficult. Further, a case may have more than one ratio. The ratios in Donoghue and Stevenson are: a duty of care is owed by the manufacturer to the consumer as a lack of opportunity existed to inspect the opaque bottle, so that's the narrow ratio, and you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. So that's another ratio. Okay, so now I've given you a hypothetical scenario to look at. Imagine you are a judge of the District Court of Queensland. On a difficult point of law, you are faced with conflicting decisions of a single judge of the Supreme Court of Tasmania and a unanimous Court of Appeal of the Supreme Court of Victoria, which precedent must you follow, if any? Could you follow a strong decision of the Supreme Court of Singapore on the point of law? So hopefully when you dissect that question and you think back over what we've discussed so far, you will look at yourself as the judge in the District Court of Queensland. So in the middle of the hierarchy, you've got a difficult point of law, and you've got conflicting decisions between a single judge of the Supreme Court of Tasmania and a unanimous Court of Appeal in the Supreme Court of Victoria. So you would see, looking at that the Court of Appeal of the Supreme Court in Victoria is a higher court in all of those structures, and they've reached a unanimous decision in that court. So both of those courts are persuasive, not binding on the District Court of Queensland, but you would be more persuaded by the Court of Appeal decision in the Supreme Court of Victoria, given that it's a more superior court. But it's still persuasive. But we look at, as I mentioned before, the judges. So the judges in the Supreme Court of any jurisdiction and the appeals level are superior to the judges at the district court level. So it's quite possible that the district court judge in Queensland would actually follow that decision. In relation to a decision of a Supreme Court in Singapore, again, that court is only persuasive on Queensland. So given all of those examples, again, I would suggest that the Appeal Court of the Supreme Court of Victoria is the most influential and the court likely to be followed on the point of law in this case. And finally, something else for you to think about. The principles of precedent only exist to enable judges to avoid making decisions. Is that the case? Is that why we have precedents, do you think? Given that we've defined precedents as being decisions made in previous cases in higher courts that are now binding on decisions in the future in lower courts, you could say, well, it avoids having to make a decision. It avoids having to go through all of the facts and consider the law in each and every case, yes. But it serves a higher purpose, and that is that those esteemed judges have considered the law and made these decisions, possibly changed previously bad law to make new precedents, so they are the best law on which we can rely. But again, something for you to think about. Now, this clearly is a much more condensed tutorial than in previous weeks, given that we can't have the interaction and I have given you the answers to all of those questions. But please think about what I've said, think about your readings, think about what you heard about in the lecture, and I invite you to email me any questions that you might have. And for those online students, I welcome them now or in our online tutorial next week. But save them up, write them down, save them up, and or email me so that I can answer any queries that you have in a timely fashion. Hopefully you've found this informative, and we will return to normal tutorials next week. So enjoy the week. Bye for now.